Welcome back to The Deep Dive, the place where we turn massive stacks of regulatory documents into immediately understandable knowledge. If you've ever had to choose how to set up a business, you know the complexity of balancing structure, risk, and, well, internal flexibility. Today, we are taking a deep, comprehensive dive into one of the most innovative and, frankly, clever pieces of legislation designed to solve that problem: the Limited Liability Partnership.
It really is a legal bridge. And we're unpacking the legislative backbone that makes this structure possible. The Limited Liability Partnership Act, 2008. This is not light reading. We're going section by section through all 81 sections and the 4 crucial schedules of the Act. So think of this as the definitive guide to the regulatory DNA of the Indian LLP.
Our mission today is, I'd say, highly ambitious: to systematically unpack the entire framework of the 2008 Act. This legislation, it received the president's assent on January 7, 2009, and was formally enacted just 2 days later. And the legislative intent here is fascinating because it was really born out of a recognized need to fill a massive void. On one side, you had, traditional partnerships with unlimited personal liability. On the other, these highly structured, pretty rigid, limited liability companies.
And that void made it so difficult for professionals. I'm talking lawyers, chartered accountants, architects, consultants, to combine their intellectual capital and grow efficiently, without risking their homes and personal assets just because a co-partner made a mistake. The LLP Act lets entrepreneurs and small enterprises combine and operate in a flexible, efficient way while offering the core benefit of limited liability.
Right, and if we had to distill the entire act into one single principle, what would it be?
It's the foundational trade-off. The LLP itself is liable to the full extent of its assets. Every single rupee it owns can be claimed by creditors. But the personal liability of the individual partners is strictly limited to the amount of capital they agreed to contribute. That shield, which is, contingent on the LLP's own solvency, is the reason this whole structure exists. That's really the lens through which we have to view every single section of this act.
Okay, let's unpack this hybrid nature then. Starting with what the LLP is in the eyes of the law. It's so much more than just a fancy partnership agreement. It is unequivocally a body corporate.
That's the starting point, exactly. It's defined under Section 2.1. And by being recognized as a body corporate, the LLP immediately gets these crucial legal attributes that are usually reserved for companies. It's a separate legal entity. The definition is also intentionally broad. It covers LLPs registered in India, foreign LLPs, and even foreign companies.
I noticed the source material specifically highlights exclusions. Why is it so important to note what an LLP isn't?
Well, it defines the boundaries of that corporate personality. The Act explicitly excludes specific non-commercial structures, like a corporation sole, which, refers to an office holder incorporated as a single entity, like a bishop or a notary. Their existence is tied to the office, not a business venture. And it also excludes cooperative societies, which are governed by their own laws and focus on mutual benefit rather than pure for-profit enterprise under this corporate statute. So knowing the exclusions helps you understand that this vehicle is purely for commercial multi-person activity.
And this separate legal status, that leads directly into the idea of perpetual succession, which is covered in Section 3. This is a massive distinction from a traditional partnership.
It is an absolute game changer for stability. Perpetual succession means the LLP's legal existence is completely unaffected by changes in the human element. If a partner dies, goes insolvent, or just retires, the LLP does not dissolve. It just continues. Imagine a high-value consulting firm structured as a traditional partnership. If one partner who holds a significant contract suddenly passes away, the firm might have to be legally dissolved. That creates massive administrative chaos, and it could jeopardize huge projects. The LLP shield prevents all of that. The business keeps running seamlessly.
And crucially, Section 3 also enforces that separation of liability. You said it before, the creditors of the LLP are creditors of the LLP alone. I, as a partner, am not personally liable for the LLP's obligations just by being part of the entity.
Absolutely. The LLP holds assets, it incurs debt, and it enters contracts in its own name. If the LLP defaults, the creditor's claim stops right at the door of the LLP's property. This is exactly why the structure is so attractive to professionals. They're risking their contribution, not their personal home.
But this legal shield, it comes with a pretty big caveat about the entity's purpose, which Section 11 clarifies. The LLP has to be formed for profit.
That's a completely non-negotiable requirement. The LLP has to be structured to carry on a lawful business with a view to earn profit. The Act is crystal clear. You cannot use the limited liability partnership structure as a vehicle for a nonprofit organization, a charity, or a social enterprise that doesn't have a profit motive. The definition of business is wide. It covers every trade, profession, service, occupation. But that intent to generate and distribute profits must be demonstrable.
Okay, so let's talk about the key mechanism that grants this personal shield, the mutual agency rule, defined under Section 26.
Hmm.
For a traditional partnership, this is like the legal death knell of personal wealth. In an LLP, it's the legal defense.
This is the single most vital piece of the Act when you compare it to the Indian Partnership Act of 1932. In a traditional firm, if Partner A signs some disastrous lease or commits a professional error, Partner B is automatically bound and potentially liable for the full extent of that damage, even if they had no clue about the act.
Right.
Why? Because Partner A is legally considered an agent of Partner B.
But Section 26 just overturns this entirely for the LLP.
Precisely. In an LLP, partners are agents of the LLP alone, not of the other partners. This means that Partner A's unauthorized or wrongful act does not automatically transfer liability to the personal assets of Partner B. This limited agency is the structural foundation for limited liability.
And that leads us right to Section 28, which confirms that limited liability. The partner's liability is generally limited to their agreed capital contribution. But we have to be specific here. When does that shield drop?
The shield drops for your own misconduct.
Period.
Section 28 is extremely clear on this. While a partner is not personally liable for the LLP's obligations solely by reason of being a partner, they are personally liable for their own wrongful act or omission. If you commit malpractice, fraud, or negligence, the LLP structure protects your co-partners, but it absolutely does not protect you from the consequences of your own actions.
Before we jump into who can be a partner, let's quickly define the small LLP under Section 2.1. This designation has a huge impact on the compliance burden, especially audits.
Right. The small LLP definition is sort of a relief valve for genuinely small enterprises. It offers them lighter compliance requirements. It's based on two quantitative thresholds that the central government can adjust over time up to very high ceilings. Currently, for an LLP to qualify as small, first, the partner contribution must not exceed 25 lakhs, though the ceiling can be prescribed higher, up to 5 crores. Second, the annual turnover, based on the statement of accounts and solvency, must not exceed 40 lakhs, with possible ceiling up to 50 crores.
So if you keep your capital and turnover below those lower limits, you can operate under a simplified regulatory regime, which has to be a major incentive for micro and small businesses.
Exactly. It recognizes that the administrative and cost burden of full corporate compliance can absolutely crush a new or tiny business. By meeting these lower thresholds, they still get the protection of limited liability while easing the mandatory audit requirements that apply to the larger LLPs.
And finally, a clean break. Section 4 confirms that the Indian Partnership Act 1932 just does not apply to limited liability partnerships. The LLP is a self-contained legal world governed entirely by this 2008 Act.
This separation is vital. It means that when you deal with an LLP, you don't have to worry about the historical baggage and the complex agency rules of the 1932 Act. Everything you need to know about its legal operation and partner relationships is contained right within the 2008 statute and the specific LLP agreement.
All right, so we've established the LLP's identity. Let's move to the people who run it. Section 5 details who can be a partner, and it's remarkably inclusive.
It's incredibly flexible. Any individual or any body corporate can be a partner. That means an LLP can be a partner in another LLP, a foreign company can be a partner, or a foreign LLP can participate. This cross-structure capability is a huge draw for complex corporate groups or, multinational joint ventures.
Are there any absolute exclusions for individuals?
Yes, and these exclusions are necessary to ensure legal capacity and financial solvency. An individual cannot be a partner if a competent court has declared them to be of unsound mind. They also can't be a partner if they are an undischarged insolvent, or if they have an active application pending to be adjudicated as an insolvent. Basically, if you're legally unable to manage your own financial affairs, you can't be responsible for managing an LLPs.
And even though it's a partnership structure, a Hindu, undivided family, and HUF cannot be a partner. Why that specific exclusion?
It's because the HUF, despite being recognized for tax and personal law purposes, is not defined as a body corporate under this act. The LLP Act requires partners to be either individuals or bodies corporate. Since an HUF doesn't fit the statutory definition of a body corporate, it can't hold a formal partner slot.
Moving to the numbers, Section 6 sets the minimum requirement, 2 partners. But the ceiling is what really sets it apart from some other structures.
The ceiling is, well, non-existent. There's no maximum limit on the number of partners an LLP can have. This allows for unlimited scalability. It makes it ideal for these massive professional service collaborations, like large international accounting firms or big law practices that want to expand indefinitely without structural constraints.
But the downside of that zero minimum is the serious structural failure warning attached to it. What happens if the LLP dips below the required 2 partners?
This is a critical risk, and it's addressed in Section 6. If the number of partners remains below 2 and the business continues for more than 6 months while it's shorthanded, the sole remaining partner loses the limited liability shield and becomes personally liable for all obligations incurred by the LLP after those 6 months.
Wow. That's a huge incentive to immediately find a new partner or just cease operations.
It's designed to enforce the fundamental requirement that a partnership, by its very definition, requires at least 2 people. And crucially, the liability only attaches if the sole remaining partner had knowledge of the situation. This prevents a partner from being unknowingly saddled with unlimited liability if they were, say, traveling internationally and totally unaware of a co-partner's sudden departure or death.
Okay, now let's discuss the designated partners, or DPs. Section 7 makes the DP role mandatory and distinguishes it from just being a regular partner.
The DP is the administrative anchor of the LLP. The Act mandates that every LLP must have at least 2 DPs who are individuals. They cannot be corporate entities themselves, though they can be nominees of corporate partners.
And the residency requirement here is paramount for accountability.
Absolutely mandatory.
Yeah.
At least one of those 2 DPs must be a resident in India. And Section 7 defines resident in India precisely, a person who has stayed in India for a period of not less than 120 days during the financial year. Okay. This ensures that even if an LLP is largely owned by foreign entities or non-resident partners, there's always a locally available, legally accountable individual responsible for compliance and communication with ROSI.
Let's run a quick hypothetical. If XYZ Limited a company and Mr. X an individual form an LLP, how is the DP requirement satisfied?
Okay, so Mr. X, the individual partner, can certainly be one DP. Since XYZ Limited is a corporate entity, it has to nominate a natural person to act as its DP. So you would have Mr. X and a nominee from XYZ Limited serving as the 2 DPs. Then you just have to ensure that at least one of these 2 individuals meets that 120-day residency requirement. If Mr. X resides in India and meets the threshold, you're good.
And every DP needs their identifier, the designated partner identification number, or DPI.
Correct. Section 7.6 mandates that they get a DPI from the central government. The Act cleverly streamlines this by stating that the rules related to the Director Identification Number, or DIN, under the Companies Act, 2013, apply mutatis mutandis, which just means, with necessary modifications, to the DPIN. So essentially, the same rigor and regulatory processes used for corporate directors apply to the key compliance officers of an LLP.
The DPs aren't just rubber stamps, though. Section 8 assigns them significant liabilities. They are the regulatory custodians.
Their primary function is administrative compliance. Unless the LLP agreement delegates the responsibilities somewhere else, DPs are solely responsible for ensuring the LLP performs all acts, matters, and things required for compliance, which includes the critical task of filing documents, returns, and statements. And more critically, DPs are liable for all penalties imposed on the LLP for any contravention of the Act. If the LLP fails, the DPs are the ones who pay the fines.
Speaking of paying fines, let's look at the financial consequences under Section 10 for basic noncompliance. These penalties are designed to hurt enough to enforce discipline.
They are. The penalties are structured with daily compounding rates, which signals that time is money in compliance. For example, failing to appoint the minimum 2 DPs or failing to meet the residency requirement, that's Section 7.1, it starts with a penalty of 10,000 rupees for the LLP plus 100 rupees for every day the default continues. And that's capped at 1 lakh for the LLP and 50,000 for every partner.
And if they fail to notify the ROSI about the DP particulars within 30 days?
That carries similar daily fines, structured a bit lower, starting at 5,000 and maxing out at 50,000 for the LLP and 25,000 for the DP. The legislature is basically saying, we gave you limited liability, but the trade-off is zero tolerance for administrative negligence. These fines are the mechanism to protect the public who rely on the LLP's status.
Okay, moving beyond the administrative roles, let's consider the actual partner relationship dynamics, specifically how a partnership interest ends, which is covered under Sections 24 and 25.
Right. A partner can cease to be a partner either through the specific provisions of the LLP agreement or, if the agreement is silent on it, by giving at least 30 days written notice to the other partners. But cessation doesn't grant you immediate freedom. Any obligation you incurred while you were a partner remains your personal responsibility.
What entitlements does a former partner walk away with?
Section 24.5 clarifies their financial rights. They are entitled to receive their actual capital contribution and their share in accumulated profits, which is calculated after deducting any accumulated losses determined as of the date they cease to be a partner. Crucially, they surrender all governance rights. They have absolutely no right to interfere in the management of the LLP's operations after they leave.
The registration of these changes under Section 25 is also critical, especially for the departing partner's own protection against this idea of holding out.
Absolutely vital. The partner has a personal responsibility to inform the LLP of any change in their name or address within 15 days. Then the burden shifts to the LLP, which has to file a notice with their ROC within 30 days of the change, whether a person becomes or ceases to be a partner or just a change in their details.
What happens if the LLP is slow or worse, deliberately defaults on filing that departure notice?
This is a really robust protection mechanism that was introduced for the partner. Section 25.6 allows the former partner to file the notice directly with the ROC if they reasonably believe the LLP is going to default. This is their safety net against future liability. If they file it, the ROC has to seek confirmation from the LLP within 15 days. If the LLP doesn't respond or confirm within that time frame, the ROC just registers the notice filed by the former partner.
So if I leave an LLP and they forget to file the paperwork, and 2 months later my old partner commits a massive error that causes a huge debt, I'm protected as long as I filed my own notice.
That is the intent. It limits the period during which you could be held accountable under the holding out principle for acts of the LLP. It ensures that your departure is officially recognized, even if the LLP's administration is, a bit sloppy.
All right, so the journey starts with incorporation, detailed in Section 11. This process immediately establishes the seriousness of forming a body corporate. 2 or more people subscribe their names, ready to carry on lawful business for profit.
And the paperwork is paramount. The incorporation document has to be filed with the Registrar of Companies, the ROC for the state where the registered office is located. It's typically done through the electronic e-form Philip. But the document itself is only half the story. The compliance statement is the crucial element of accountability.
That compliance statement, it acts as a foundational, legally binding promise, doesn't it?
It's the integrity check at the very beginning. The statement must be made by a qualified professional, an advocate, a chartered accountant, a company secretary, or a cost accountant who is engaged in the formation, and by at least one of the subscribers. They are jointly declaring that all the requirements of the LLP Act and its associated rules regarding incorporation have been fully complied with.
And the penalties for lying at this foundational stage are significant. It really sets the tone for the entire life of the LLP.
Section 11.3 treats this declaration with the utmost seriousness. If a person makes a statement knowing it to be false or not believing it to be true, they face both criminal and financial penalties. We're talking imprisonment up to 2 years and a fine that ranges heavily from 10,000 rupees up to 5 lakhs. This level of punitive action really underlines the state's demand for truthfulness when you're seeking the privilege of limited liability status.
Once that's filed, Section 12 dictates the registration process. It sounds straightforward, but the time limit for the ROC is important.
Right, the registrar has 14 days to review the documents, and if they're satisfied that the requirements have been met, they must register the document and issue the Certificate of Incorporation, or COI. This COI is the final word. The Act specifies it as the conclusive evidence that the LLP has been incorporated by the name mentioned in it. It's basically the birth certificate of the legal entity.
And with that certificate, Section 14 confirms the powers of the new body corporate. What can it suddenly do that the partners couldn't do individually?
Everything a separate legal entity can do. It gains the capacity to sue and be sued in its own name. It can acquire, own, hold, develop, and dispose of all types of property, tangible or intangible, movable or immovable. It can, if the partners choose, have a common seal, though that's optional now, unlike in some older company structures. Essentially, it steps onto the commercial stage as a completely independent player.
Let's shift to identity management, specifically the naming rules under Sections 15 through 17. The first rule is the non-negotiable suffix.
Correct. Section 15.1 requires the name to end with Limited Liability Partnership, or LLP. This is crucial for consumer and creditor protection. Anyone dealing with the entity must be instantly aware that the entity they are engaging with offers limited liability protection to its owners.
And the restrictions under Section 15.2 are really designed to prevent market confusion or abuse.
They protect existing businesses. A name cannot be registered if the central government deems it undesirable, maybe implies a government association, or if it is identical or too near, resembles the name of any existing LLP, company, or a registered trademark. The goal is just clear identity in the marketplace.
So if I'm planning my new venture, I need to reserve that name before I do the full incorporation. Section 16 outlines this reservation process.
Exactly. You apply to the registrar, and if the name is deemed permissible, the registrar reserves it for a period of 3 months from the date of intimation. This gives you a window to finalize your LLP agreement, gather capital contributions, and complete the remaining statutory formalities without the risk of losing your chosen brand name.
But sometimes mistakes happen, or a trademark is registered later. Section 17 provides the mechanism for mandatory name rectification.
Right. If an LLP is inadvertently registered with a name that is identical or too similar to an existing one, whether it belongs to another LLP, a company, or a trademark proprietor, the central government can step in. Upon receiving an application from the affected party, the CG can direct the LLP to change its name within 3 months.
What's the timeline for the trademark owner to seek this correction?
The trademark proprietor has a limited window. Their application has to be made within 3 years from the date the LLP was incorporated or the date it changed its name. This prevents ancient dormant trademarks from suddenly being used to disrupt active LLPs decades down the road.
And if the LLP just ignores the central government's direction to change its name?
The government won't let the confusion stand. Section 17.3 dictates that if the LLP fails to comply within the 3 months, the central government will allot a new name to the LLP, and the ROUC will issue a fresh certificate of incorporation reflecting the new government-chosen name. The LLP basically loses control of its identity, which is a very strong motivator for compliance.
Now we move to the heart of the matter, liability. We've established the core protection, but Section 27 defines the boundaries of the LLP's liability to the outside world.
This section governs when the LLP is bound by a partner's actions. The LLP is generally responsible for the acts of its partners carried out in the usual course of business. However, the LLP is not bound if the partner had no authority to act, and the third party dealing with them either knew that the partner lacked authority or didn't know or believe that the person was actually a partner of the LLP.
So if I, a partner, try to take out a $50 million loan for the LLP, and the LLP agreement restricts that authority to the designated partners only, and the bank knows about that restriction, the LLP is protected from my unauthorized act.
Precisely. This protects the LLP from what we call ultra-vires acts, especially when the third party is on notice. But crucially, the LLP is liable for a partner's wrongful act or omission committed in the course of the business or with its authority. If a partner is negligent while performing the LLP service, the LLP is liable for damages.
But Section 27.3 and 4 really solidify the partner's personal shield.
They absolutely do. They reiterate that the obligation, whether it's from a contract or a tort, is solely the obligation of the LLP, and all liabilities must be met exclusively out of the LLP's property. The limited liability shield of Section 28 remains firm unless, of course, the partner committed the wrongful act themselves.
Let's discuss holding out under Section 29, which deals with misrepresentation. This is relevant both for non-partners pretending to be partners and for former partners who haven't filed their paperwork.
Holding out is all about managing external appearances. If a non-partner, through their words or conduct, represents themselves or knowingly allows themselves to be represented as a partner, they become personally liable to anyone who relied on that representation and extended credit to the LLP. Their liability is based on reliance, not on actual partnership status.
Is the LLT entirely off the hook when someone is holding out?
Not entirely. The LLP is liable, but only to the extent of the credit or financial benefit actually received by the LLP as a result of that representation. If the person holding out took the money and ran, the LLP is not liable. If the money made it into the LLP's accounts, the LLP is liable for that amount.
And there's a compassionate clause in there about deceased partners' names.
Yes, Section 29.2 is a clarification based on historical partnership law. The simple fact that the LLP continues to use the name of a deceased partner as part of the firm name does not make the deceased partner's estate liable for acts done after their death. This prevents unnecessary legal battles and ensures the continuity of goodwill and branding.
This brings us to the most serious provision in the entire Act, the ultimate threat to the limited liability shield. Unlimited liability in case of fraud, Section 30. This is where the protection just immediately vanishes.
This is the regulatory sledgehammer. It's designed to maintain ethical conduct. If any act is carried out by the LLP or any partner with the express intent to defraud creditors or for any other fraudulent purpose, the limited liability vanishes.
And who suffers the consequences?
The liability of the LLP and the specific partners who were knowingly involved in the fraudulent act becomes unlimited for all debts and liabilities of the LLP. This means the personal assets, the house, the savings, the investments of those fraudulent partners are immediately exposed to the full extent of the LLP's debts. This is the government's unequivocal answer to preventing the abuse of limited liability.
And the consequences are not just financial either. They're criminal.
Absolutely. Partners who are knowingly involved face serious jail time imprisonment up to 5 years and a heavy fine ranging from a minimum of 5,000 rupees up to 5 lakhs. Furthermore, the fraudulent partners or employees are personally and directly liable to compensate any person who suffered losses or damages due to that conduct.
So if a partner fraudulently overvalues the LLP's assets to secure a loan and that loan defaults, not only does the partner face jail time, but their personal wealth is available to repay the debt, and they must individually compensate the bank for damages.
That summarizes the complete exposure perfectly.
Yeah.
However, Section 33 does offer the LLP itself a defense. The LLP is not liable to pay compensation if it can prove that the fraudulent partner or employee acted without the knowledge or authority of the LLP. The liability is highly targeted at the specific individuals who perpetrated the fraud.
Given the severity of Section 30, the Act provides a powerful counter-mechanism to uncover these acts, the whistleblowing protection under Section 31.
This is a crucial modern safeguard. It encourages internal honesty. If a partner or employee provides useful information to the court or tribunal during an investigation, information that ultimately leads to the conviction of the LLP or another partner or employee, the court or tribunal has the authority to reduce or even waive any penalty imposed on the whistleblower.
And the protection against retaliation is robust.
Extremely robust. Section 312 ensures this. The whistleblower cannot be discharged, demoted, suspended, threatened, or harassed merely because they provided that information. This statutory protection is designed to give individuals the security they need to expose misconduct without fear of losing their livelihood, which in turn increases the effective enforcement of the anti-fraud provision.
Moving on to the financial engine of the LLP. Contributions, detailed in Sections 32 and 33, are the lifeblood of the entity and the basis for limited liability.
The Act is highly accommodating about the form of contribution. It's not just about cash. Section 32 allows contribution to be tangible, property movable, or immovable, intangible property. Money, promissory notes, agreements to contribute cash or property, or even contract for services already performed or services yet to be performed. This flexibility is perfect for professional firms where, intellectual property or skilled services are the primary capital.
Since it's not just cash, how does the Act ensure these contributions are real and measurable?
Section 33 requires that the monetary value of every partner's contribution must be properly accounted for and disclosed in the LLP's accounts. The ultimate obligation of a partner to contribute is determined by the specific terms laid out in the LLP agreement. That agreement is the commercial contract that sets out the internal risk profile.
But what if I am a creditor who sees the LLP agreement promising a 1 crore contribution from a key partner, and I extend a loan based on that promise, only to find out the partners later secretly compromised and reduced that contribution to 10 lakhs?
Section 332 is a protective measure against exactly that scenario. A creditor who extends credit relying on the original contribution obligation stated in the LLP agreement and who has no notice of any subsequent compromise between the partners can still legally enforce that original 1 crore obligation against the partner. This prevents partners from unilaterally reducing their stated risk exposure after receiving external funding.
This transparency and accountability lead us directly to the mandatory financial compliance requirements, starting with Section 34, Books of Account, BOA, and the Statement of Account and Solvency, SIS. This really is the price of the limited liability shield.
Maintaining proper books is completely non-negotiable. The LLP must maintain proper BOA for each year of its existence, using the double-entry system of accounting. They can choose to keep books on either a cash or accrual basis, but they must be kept at the registered office for the prescribed period.
And the timeline for the Statement of Account and Solvency, the SAS.
The SAS must be prepared within 6 months of the end of the financial year, signed by all designated partners, and promptly filed with the ROC. The standard FY runs April 1st to March 31st. The S isn't just a balance sheet, it's a solemn declaration by the DPs that the LLP is financially solvent, which is why all DPs have to sign off on it.
What if the LLP is brand new? Does it have to file for a very short period?
The Act offers a practical concession here. If an LLP is incorporated after September 30th of a given year, its first financial year may be extended to March 31st of the next following year. This prevents a startup from having to file comprehensive accounts for a period of only a few weeks.
What about mandatory audit requirements? Does every single LLP need an audit?
Section 34(4) mandates that accounts shall be audited as prescribed. However, the central government has the power to exempt certain classes of LLPs from this requirement. This exemption typically targets the small LLP category we discussed earlier, reducing the administrative burden on the smallest entities. And Section 34A mandates that the CG, in consultation with NFRA, the National Financial Reporting Authority, will prescribe the accounting and auditing standards recommended by the ICAI, ensuring regulatory quality.
In addition to the SAS, the annual return, or AR, is mandatory under Section 35. What's the deadline for this filing?
The AR must be filed with the OAC within 60 days of the closure of the FY. So if your financial year closes on March 31st, your annual return is due by May 30th. This annual return provides the registrar with critical updated information about the partners, their contributions, and any changes in the LLP structure.
Let's dedicate some time to the severity of penalties for failure to comply with these financial requirements, because they're structured to be extremely punitive.
They really reflect the state's philosophy. If you enjoy limited liability, you must provide transparency. Simple failure to file the SAS or the annual return results in a daily penalty of 100 rupees. This is subject to a high maximum, 1 lakh for the LLP and 50,000 for every designated partner. This compounding structure is designed to ensure prompt action.
But the fines for fundamental failures, like not keeping books or skipping a mandatory audit, are much, much higher lump sums.
They are failure to maintain proper books of account, failure to prepare or file the SAS, or failure to conduct a mandatory audit result in a minimum fine of 25,000 rupees, extending up to a heavy 5 lakhs for the LLP. And the DPs are again targeted, a minimum of 10,000 up to 1 lakh for every designated partner. These are not trivial administrative costs. They represent a serious financial risk if compliance is neglected.
And if you actively lie in those financial filings, Section 37 imposes criminal punishment, similar to the initial incorporation fraud.
Yes. Making a false statement or omitting a material fact in any required return or document, if it's done knowingly, carries imprisonment up to 2 years and a massive fine ranging from 1 lakh to 5 lakhs. The regulatory message is consistent. Limited liability requires absolute honesty and transparency.
The ROCIAs isn't just sitting there waiting for filings. Section 38 gives them active enforcement powers of inquiry.
The registrar is empowered to require any person, including current or former partners, DPs, or even employees, to provide information in writing or appear in person. They can summon people to clarify documents or provide missing information. Failure to comply with these requisitions carries a penalty of 2,000 up to 25,000 rupees.
Lastly, Section 39 offers a reprieve for certain administrative mistakes. Compounding of offenses.
Compounding is essentially an out-of-court settlement for minor offenses. The regional director, or RD, or an officer of similar rank, can compound offenses that are punishable solely with a fine. The compounding sum must fall within the minimum and maximum fine prescribed for that specific offense.
Is there a limit on how often a firm can use this mechanism?
Yes, to prevent serial violations. Compounding is barred if the LLP or partner committed a similar offense within the preceding 3 years. However, if the firm manages to stay clean for 3 full years, a subsequent offense is treated as a first offense, restoring the option of compounding.
That 3-year reset is important. Does the RD have any extra teeth when they grant compounding?
They do. When compounding an offense, the RD can direct the partners or DPs to file any overdue documents. Failure to comply with that specific order results in a penalty that is twice the maximum fine provided for the original offense. It's a mechanism that forces overdue compliance even during the settlement process.
Let's discuss the life cycle beyond day-to-day operations, starting with the transfer of partnership interest under Section 42. This section really reinforces the separation between financial rights and governance rights.
It clearly delineates the tradable part of the partnership interest. A partner's rights to a share of profits, losses, and distributions are fully transferable, either wholly or in part. This means the economic interest can be sold or assigned, much like a share in a company.
But selling my revenue stream doesn't mean I can sell my vote, right?
Exactly. The transfer of these financial rights explicitly does not cause the disassociation of the original partner or trigger the dissolution or winding up of the LLP. Furthermore, the transferee, the person receiving the economic right, is explicitly not entitled to participate in the management, nor can they access transaction information. It ensures business continuity while allowing partners liquidity for their financial investments.
This flexibility extends to conversion. Sections 55 through 57 and their corresponding schedules offer clear structured pathways for existing, often unlimited liability, firms to adopt the LLP structure.
The Act anticipates business growth and the desire for limited liability. The second schedule outlines the conversion of a traditional partnership firm into an LLP. That's Section 55. The third schedule provides the process for converting a private company into an LLP, which is Section 56. And the fourth schedule covers the conversion of an unlisted public company into an LLP, Section 57.
Why is there a specific exclusion for listed companies?
Listed companies, by their very nature, involve massive public interest and investment. Converting them to an LLP, which has a less stringent governance structure than a full public company and which trades shares less publicly, would undermine investor protection. The LLP structure is fundamentally designed for private arrangements, even if they're very large.
What happens the moment that conversion is registered? Section 58 details the powerful legal effect.
It's a seamless transition of legal identity. Upon registration and conversion, Section 58 dictates that all property, assets, rights, privileges, liabilities, and the whole undertaking of the former entity are automatically and unequivocally transferred to and vested in the newly formed LLP. No complex assignment deeds or further assurances are needed.
And the former entity vanishes.
It is deemed dissolved and removed from the register of firms or companies. The LLP then has the minor administrative duty of informing the former registrar of firms or companies within 15 days of its successful conversion. The business continues uninterrupted under the new legal protection.
Once incorporated, Section 60 introduces the framework for dealing with financial distress or major structural change through a compromise or arrangement, or CA. The National Company Law Tribunal, the NCLT, takes the lead here.
Right. If the LLP proposes a compromise with its creditors or an arrangement with its partners, maybe adjusting the debt load or internal contribution ratios, the NCLT manages the process. The tribunal may order a meeting of the affected group. For that compromise to be sanctioned, it requires agreement by a majority representing 3/4 in value of the creditors or partners present and voting, followed by the final sanction of the tribunal.
3/4 in value is a very high threshold.
It is, which ensures that a small group of partners or creditors can't be steamrolled by a simple majority. Once it's sanctioned, the LLP must file the NCLT's order with the revocee within 30 days. The arrangement only becomes legally effective upon this filing.
Section 62 extends the tribunal's power to manage corporate events like reconstruction and amalgamation. Can an LLP merge with a company or only with other LLPs?
Based on the source material context, LLPs cannot amalgamate with companies. They can only amalgamate with other LLPs. When the NCLT sanctions a scheme for the reconstruction or amalgamation of 2 or more LLPs, the order covers everything from the transfer of liabilities to the dissolution of the transfer LLP without a formal winding up process.
What is the primary safeguard the tribunal has to impose before approving a merger or reconstruction?
The tribunal must receive a crucial report, usually from the revocee and sometimes the official liquidator. This report has to confirm that the affairs of the LLPs have not been conducted in a manner prejudicial to the interests of its partners or, more broadly, to public interest. This prevents amalgamation from being used as a maneuver to hide or escape previous financial misconduct.
Finally, let's cover the end of the LLP's life, winding up and dissolution under Sections 63 and 64. Winding up can be voluntary or mandated by the tribunal. What are the specific red flags that trigger a tribunal-mandated winding up?
Section 64 lists 5 grounds that expose an LLP to judicial winding up. First, if the LLP itself passes a resolution deciding it should be wound up by the tribunal. Second, if the number of partners remains reduced below 2 for a period exceeding 6 months, that compliance failure we discussed earlier is a structural threat.
What's the most significant compliance-related trigger?
The fourth ground is a massive deterrent to administrative laziness. If the LLP defaults in filing both the statement of account and solvency and the annual return for any 5 consecutive financial years, 5 years of zero compliance signals that the entity is either dormant and dangerous or abusing its status, which necessitates judicial intervention.
that's a strong reminder that the limited liability comes with a mandatory accountability timeline.
It is. The fifth ground is the general, just, and equitable provision, which allows a tribunal discretion to wind up the LLP if, based on the facts, continuing its existence would be unfair or unsustainable.
Let's round out the Act with a few final, powerful miscellaneous provisions. Section 66 deals with a partner acting as an external creditor to the LLP.
This reinforces the separate legal status concept we opened with. If a partner lends money to or transacts other business with the LLP, say, providing office space or selling raw materials, they're treated identically to a non-partner. If the LLP becomes insolvent, that partner, in their capacity as a lender or vendor, holds the same rights and obligations as any ordinary external creditor for that specific transaction.
Section 67 provides a critical regulatory flexibility mechanism, the application of the Companies Act 2013 to LLPs.
This power allows the central government to maintain regulatory coherence and efficiency. The CG can apply provisions of the Companies Act 2013 to LLPs, including any necessary exceptions or modifications via a notification. This prevents the LLP Act from becoming instantly outdated when company law evolves, ensuring harmonization where it's appropriate.
But the legislature retains oversight, correct?
Crucially, yes. A draft of any such notification must be laid before Parliament for 30 days for scrutiny and approval or modification by both houses. This ensures that the executive branch doesn't unilaterally impose company law obligations on LLPs without legislative review.
And finally, Section 70, enhanced punishment, is the last word in enforcing adherence to the law. It targets repeat offenders.
This is pure deterrence. For a second or subsequent offense by an LLP, partner, or DP, the punishment is explicitly enhanced. If the offense involves a fine, the imposed penalty shall be twice the amount of the fine prescribed for the original offense, over and above any imprisonment provided. The financial cost of recidivism is doubled immediately.
To bring this comprehensive deep dive together, let's synthesize the benefits and burdens by comparing the LLP structure with its two primary alternatives, the traditional partnership firm and the limited liability company.
Comparing the LLP with a traditional partnership firm really highlights the massive leap in legal protection provided by the 2008 Act. The LLP is a mandatory registered body corporate with perpetual succession and a separate legal entity. A traditional firm lacks all of these features. It's not a distinct entity from its partners and can dissolve instantly upon a partner's departure.
And the liability differential is the practical reason for the LLP's existence.
Without a doubt, LLP liability is limited to the agreed contribution, shielding personal assets. A traditional firm's liability is unlimited, exposing the partner's personal wealth. And remember that critical mutual agency rule. In an LLP, Partner A's mistake doesn't bind Partner B's personal assets. In a firm, it does.
Plus, the mandatory corporate rigor of the LLP, the DPs, the SS, the annual return filings, that's all absent in a traditional firm. This rigor is the necessary price for the liability shield.
And for international collaboration, the LLP is the only choice. Foreign nationals can be partners in an LLP, but not in a traditional firm. The LLP structure is designed for the modern, globalized professional.
Switching gears, how does the LLP compare to the much more formal limited liability company? Where does the LLP retain its operational advantage?
The comparison to a company highlights the LLP's inherent flexibility. Both are bodies corporate, both are governed by statute, and both offer limited liability. However, the internal governance is fundamentally different. For a company, internal management is highly rigid, controlled by the Companies Act 2013, and managed by a statutory board of directors.
Whereas the LLP?
The LLP's internal governance is highly flexible. It's determined primarily by the LLP agreement, a contract between partners. This allows the partners to customize decision-making ratios, profit sharing, and management roles far beyond what is possible under the rigid hierarchy of a company board.
And even the limited liability calculation is subtly different, isn't it?
Yes. In an LLP, liability is limited by the extent of the agreed contribution of the partner. In a company, liability is limited to the unpaid amount on the shares held by the member. This makes the LLP structure ideal for professional collaborations, where human capital and expertise are the primary inputs, rather than massive financial share capital.
So the LLP is perfectly suited for professional practices, where autonomy and customized internal agreements are valued, but the protection of personal wealth is essential.
That is the ultimate conclusion. It's knowledge capital intensive, offering the stability of a body corporate without the governance rigidity of a board of directors.
So we've navigated the entire legal framework of the Limited Liability Partnership Act 2008. We've established its hybrid identity as a body corporate with separate legal standing and perpetual succession. We've delved deep into the non-negotiable role and liability of designated partners, mapped out the risks of incorporation, and perhaps most importantly, explored the absolute zero-tolerance policy against fraud.
The key synthesis for you, the listener, is recognizing the sophisticated legal engineering behind this act. It successfully blends the ease of a partnership with the protective shell of corporate status.
But the price of that hybrid benefit is the rigorous continuous corporate compliance, the SS, the AR, the mandatory DPs enforced by escalating financial penalties, and the terrifying threat of unlimited personal liability should you or your partners engage in fraudulent conduct under Section 30.
That tension is the central operational reality of the LLP. The LLP Act 2008 essentially asks entrepreneurs, how much administrative discipline are you willing to maintain in exchange for the legal security of limited liability? The detailed provisions of the Act are the government's answer to ensuring that limited liability does not become a tool for unlimited misconduct or irresponsibility.
The ultimate takeaway for you is this. Embrace the protection the LLP offers, but understand that the paperwork is not optional overhead. It is the cost of your personal shield, and neglecting it is the quickest way to lose the benefit you sought in the first place.
Now go apply this knowledge, but before you do, check Section 7 again. Those 120 days of residency are non-negotiable.
We'll see you next time on The Deep Dive.